ऊपर नहीं ज़्यादा ऊपर वो आ रहा है।
The council seeks permission to collectively refer to the tribunal as the honourable bench and individually refer to the members as your lordship. Much obliged. Good morning to the honourable bench. Today, my co-counsel and I will be representing the appellant in the matter of Ibra Kadabra versus Trickster and Competition Commission of Florida. We have approached the tribunal under Section 53B of the Competition Act. Indeed, your lordship. It is contended that firstly, Trickster has entered into a tie arrangement by mandating the use of Rodeo, which is its own payment service app, and this mandatory clause causes an AEC in the market, hence holding it in contravention of the Competition Act. Secondly, it is also contended that Trickster is collecting personal details of consumer alongside other data, and such data must be shared with its competitors so that they can. Your lordship, as per the proposition, only Trickster has the first mover advantage, and they are collecting the data. Indeed, your lordship, we are in the market of providing online intermediary services for selling movie tickets in the state of Florida. On Trickster's platform, yes, but on our platform, as per the proposition, no, your lordship. In order to any use, so there is a two-sided market, and whenever consumers come on the platform and try to buy the movie tickets, they pay through an online service and they get the movie tickets on their mobile phone itself. Is your lordship be kind enough to rephrase the question? Indeed not, your lordship, because the transaction data that is there does not involve the personal details of the consumer. Alongside, Trickster is also collecting data specific to the genres of the movies that the consumers might like, along with their GPS details. And all. Indeed, your lordship, if the bench has been apprised with the relevant facts, the council will move on with issue number 1. Much obliged. At the outset, the council wishes to define the relevant market in the present case, and it is an issue of contention only regarding the relevant product market. In this regard, it is submitted that the relevant product market in the present case must be defined as the market for providing online intermediary services for selling movie tickets. In this regard, the council will be making a two-fold submission, wherein firstly it is submitted that online and offline channels of distribution are separate product markets, and secondly, within the online channel, online intermediary services in themselves constitute a separate relevant product market. Moving on with the first fold of the submission, it is indeed, your lordship, because of the distinct convenience that is provided to the consumers in the online sphere, it is held that they are to be constituted as a separate relevant product market, and they cannot be substitutable on the basis of external characteristics and also on the basis of their intended usage. Indeed, your lordship. Indeed, not, your lordship. The precedent in the present case is twofold. Firstly, we can place relevance on the Mohit Manglani versus Flipkart case, where the Competition Commission stated that it is very relevant to define the relevant markets in different online and offline spheres. And secondly, in the All India Online Vendors Association versus Flipkart case, it was held that due to the distinct convenience that online marketplaces provide to the consumers, it is a separate relevant product market. Yes, indeed, your lordship. There is a judgment by the name of Ashish Ahuja versus Snapdeal, but that's a 2014 judgment, your lordship, and other judgment that has been cited by the council at 2018 judgment. Additionally, your lordship. Indeed, not, your lordship. The law of precedent, there is no such precedent in the Competition Commission, and it has to be analyzed on a case-to-case basis pertaining to the relevant market that is in question. And because of the indeed, your lordship, they are the same relevant market, but it was considered that during the Snapdeal case, it was easier for the consumer to shift to the brick and mortar store. But in the Flipkart case, it was considered that even if the prices rise, the consumers prefer the convenience of the online platforms. And for indeed, the lordship may rephrase the question. counsel is not aware about that, Your Lordship, but it was held that even if it is considered because of the recency of the case and also because of the market, the consumer substitution in this market, it is considered that online and offline are separate relevant product markets. With respect to the second pole of the submission, it is submitted that online intermediary platforms are a separate relevant product market, and this is submitted with regard to the SCB functionality test. The SCB functionality test revolves around the search, compare, and booking features that are given by two-sided market platforms. From one side, they allow the sellers to list their products on the platform. In this case, the theaters and multiplexes can list their tickets. And from the other side, they allow the consumers to come to the platform, search, compare, and book between the various options that are available, and then book the option that suits them the most. And because of this specific feature, which is only given by online intermediary services, it is contended by the council that that the relevant product market in the present case is the market for providing online intermediary services in the state of Florida. If the Lordship permit, I'll be moving on to issue number 1. The first issue revolves around whether players in the market. There are two major players in the market as per the players. There is not a specific number given, but it is given that Fixer has 30 to 35% market share, followed by Ibra Kadabra with a 15 to 20% market share, followed by Thunderbird, which was an entity with 8% market share but has been acquired by Fixer, and then all other market players have 5% or less. Your Lordship, it is now contended that regarding the tie-in arrangement that has been entered into by Trickster, it is going to be a two-pronged submission, wherein firstly it is submitted that it is in contravention of Section 3, Subclause 4, Part A of the Competition Act, read along with Section 3, Subclause 1, and secondly, it is an abuse of dominant position under Section 4, Subclause 1 of the Competition Act. Moving on with the first prong, it is submitted that whenever any tie-in arrangement that is entered into in which two different relevant products are tied belonging to different relevant product markets, it is considered as a tie-in arrangement, and this is as per the explanation, as per the definition given in the explanation in Section 3, Subclause 4, Part A of the Act itself. In the present case, two different products are being tied. First is the service for providing online intermediary services, and second is the product for online payment services platform. And in this regard, it is submitted that as this time arrangement causes an AEC in the relevant market, it is contended that it is in contravention of the Competition Act. Suppose Fixer says you can use one of three modes of payment out of the 50 that are available, as opposed to only one. Does that make a difference? Indeed not, Your Lordship, because Section 3, Subclause 1 is an independent clause, and any condition which restricts the choice of consumer and harms consumer is in opposition of the consumer welfare. I can understand your even saying you only use radio, that's probably a problem. So it says I'm giving an option of three, and they have to integrate it onto the Fixer platform. So for whatever reason, technologically or for safety reasons, I think they will do one of three. And there are 50 other options in the market. Why should it not make a difference? And why should Fixer not have the ability to say, you are transacting on my platform, I will only deal with you on platform A or on payments platform A and not B? Indeed not, Your Lordship, because such a condition leads to restriction of consumer choice and it leads to consumer harm. And whenever the choice is being restricted of a consumer owing to a time arrangement, it is said to cause no accrual of benefit to the consumer and is a negative factor. Indeed not, Your Lordship, this is not a presumption. Whereas its relevance is based on the memorandum on page number. Who has the burden to prove the possibility of the existence of harm in a 3-4 case? In a 3-4 case, the informant has to prove to the commission or the tribunal that a prima facie case exists, and the Director General has to, after the prima facie case has been established, the Director General has to carry this on. With respect to the first prong of the AAC argument, it is submitted and concluded that as the restriction of choice in the present case causes the consumer harm, it is contended before the Honorable Bench that Trickster's tie-in arrangement is leading to no accrual of benefit to the consumer. With respect to the second prong of the submission, it is submitted that Trickster's tie-in arrangement also causes AEC in the market because of it has the likeliness to drive out competitors and cause a foreclosure effect. Whenever consumer harm and AEC are different, indeed not, Your Lordship. The consumer harm is one factor. Additionally, the foreclosure effect of the competitors is another factor, and as the negative factors will be outweighing the positive factors in the present case, AEC is constituted. Has there been any evidence of a competitor being foreclosed? No, Your Lordship. As per the property, there has been no evidence. But even the yardstick for likely to cause. Likely to cause is because they face a decreased demand for their product and they will not be able to acquire a 30 to 35% of the market share just because Trickster has tied such market share, and Trickster has significant network effects which will only lead to the rise of their market share, and for these reasons likely entry into the market is going to be helpful. Various other entities
the others, suppose there are more than one, who have 5% market share, you also be at 25.
Indeed not, your lordship.
Apart from access to the same source of funding as you, you are both unicorns.
Indeed not, your lordship. Even when we are unicorns and have high EBITDA as companies, both of us companies, still, your lordship, because Pixar has high net worth individuals from both Florian origin as well as the international religion, international areas like Russian Federation. They have significant economic power, which allows them to dominate in the market and also acquire the other competitors in the market, which is not exercised by us or any other smaller competitors in the market.
So this kind of assessment is done over a slightly longer period. I mean, 1-2 year threshold is too much, and especially when you deal with technology.
Indeed not, your lordship. Another contention before the Honorable Tribunal is that it is a very growing market, and if Twitter is able to acquire the market in a sense that it drives out other competitors, it could lead to a monopolistic tendency which will not allow other competitors to compete or even new competitors or entrants to make entry into the market.
That's something that ultimately any acquisition it does today also comes to Competition Commission for approval, right? There is, in a sense, the legislative and a statutory mechanism to prevent that monopolistic attitude or temperament from growing. Why should we interfere at this stage? The market works itself out. It almost seems like there are different competitors.
Indeed not, your lordship. Whenever any acquisition is done or any other anti-competitive agreement has been entered into, it is contended that it has a likely possibility to cause an applicable adverse effect of competition. That tribunal and the commission have to look into it.
They can't be yardstick for AEC.
The yardstick for AEC, as per the Act, is the factors defined in Section 19, subclause 3, where there are 6 factors.
Please apply those to the facts of this case.
Indeed, your lordship. The first factor,
and while doing so, I mean, you had mentioned that this market is characterized as network effects, right? So, I mean, is network effects always a bad thing? I mean, in terms of when weighing the pros and the cons of the EEC and 1903, there could be some efficiencies coming out of network effects as well, right? So maybe you want to factor that in when you're addressing the question.
indeed, your lordship. Firstly, answering question regarding the network effects. Because of the network effects that are existing in this two-sided market, Pixar is able to vertically integrate with the upstream and the downstream players. So what happens essentially is that whenever there is a competitor with the highest market share in a two-sided market, even the sellers want to list their products on their platform because they have access to a greater consumer base. And from the other side, the consumer will only go to the platform which have an exclusive portfolio of upstream or downstream players. And because of this reason, it is causing foreclosure of competition to the other competitors in the market, or it is creating a barrier for entry for new entrants. And for these reasons, network effects in the present case do cause an AEC. With respect to your question, your lordship, regarding the factors given in Section 19, subclause 3, Section 19, subclause 3, Part D defines accrual of benefits as a positive factor. But in the present case, because of the restriction of choice to the consumers owing to the time arrangement, it is indeed causing a negative factor. And for this reason, because of the restriction of choice, it harms consumer welfare. The positive factors are not satisfied.
Also, this one question you are applying, who is the respondent?
Pixar and Competition Commission.
Competition Commission is also a party here,
Indeed, your lordship.
and is somebody representing them?
Indeed, your lordship. The opposite party two councils are represented. Indeed, your lordship. Moving on with the other factors, your lordship. Another factor is the likely possibility to drive out competitors from the market or raise barriers to entry as per Section 19, subclause 3, Part B and C of the Act. In that respect, it is submitted that whenever the competitors or the new entrants face a reduced demand for their product, they will not be able to acquire the market share, and in a time arrangement, 30 to 35% of the market share in the present case is being tied, and for that reason, it is causing a negative foreclosure effect on the market and is likely to drive out competitors from the market. And because of these two reasons, it is submitted that as the negative factors are outweighing any positive factors that are submitted by the opposite parties, the Pixar time arrangement causes an appreciable adverse effect on competition in the market and is in contravention of Section 3, subclause 1 of the Act.
There is the fact that there is a guaranteed 50 to 35% share, market share, also as another says, give rise to several consumer benefits. You have the ability to use that leverage, you have the ability to make it more efficient, you have the ability to offer cheaper prices, all of that. And there is a 70%, 55 to 70% market which is still available for all.
Indeed, not
50% be the benchmark.
Your lordship, if you may repeat the question.
I'm just asking you, why 30%? I can understand your leader was 50 plus, why 30? 30, 35, 42 is all right. I mean, and there are enough players in the market. It should be a dynamic growing market.
Indeed not, your lordship. This will be answered in a two-part submission. The first submission is regarding the dominance of Pixar, which is because of the 35% market share and the additional factors mentioned in Section 19, subclause 4. That will be addressed now by the council, but to shortly answer a question, their ability to vertically integrate, their ability to raise the technical entry barriers, and also because of their high economic power, they do have a dominant position in the present market, even though they have a 30 to 35% of the
Yeah, dominance is that.
Indeed not, Your Lordship. Abuse of dominance will also be proved. Where is the evidence of abuse? Yes, indeed, Your Lordship. Before moving on to the abuse of dominance question, another question that was posed by Your Lordship was regarding how trickster is in a dominant position, and the dominant position arises out of the factors of economic dependence and other factors. Regarding the abuse of dominance, Your Lordship, it is contended that it is an abuse of dominance on three grounds. Firstly, it is a denial of market access in any manner as per Section 4, Subclause 2, Part C of the Competition Act. Secondly, it is an irrelevant supplementary condition owing to Section 4, Subclause 2, Part D of the Competition Act. And lastly, it is a leveraging of dominant position with respect to 4, Subclause 2, Part D of the Competition Act. With respect to the first submission, Your Lordship, because Fixer is able to collect consumer data, and collection of consumer data entails huge costs for other competitors, and as the other competitors, especially the newer entrants or the smaller competitors, do not have the economic backing to collect, accumulate, or analyze the consumer data.
You say do not. Do they have access to the same sources of funding or do they not?
Indeed not, Your Lordship. Its relevance is based on the list of clarification. Point number 16 on page number 3, Your Lordship.
What does it say?
It says that Fixer has raised funds from several investors, including both foreign and foreign origin, and which include HNI, that is high net worth individuals from the Russian Federation.
I'm sorry, again, so where is the evidence to suggest that you also don't have and others in the market don't have access to funding? It doesn't matter if you wait for the Russian Federation or from the HNI in the Russian Federation. Practical matter is all of you have access to money.
Indeed not, Your Lordship. As per the fact proposition, no relevant information is given how the economic backing of the smaller competitors in this case. And with respect to Ibra Cadabra, also it is only given that it's a unicorn valuation company with a high EBITDA. It does not have the capability or the investment to endure seasonal losses, which is with Fixer. Additionally, Your Lordship, we also had a contention regarding how we can compete on the price factors. Fixer has entered into a memorandum of understanding with various multiplexes in which they have imposed price parity obligations, and they have also imposed an exclusive distribution agreement which leads to a refusal to do. As whenever that MOU is signed by such multiplexes, they are not able to sell their tickets on our platform or any other booking platform. And for these reasons, Fixer is only able to increase its market share and abuse its dominant position.
Are there any efficiencies coming out of price parity?
Indeed not, Your Lordship.
Are they per se anti-competitive?
Indeed not, Your Lordship. It will be contended by my co-counsel as well that it is not per se anti-competitive, and it is causing an interest in the market. But to shortly answer your question, because it's a wide price parity clause, which restricts the other competitors in the market to deal in such consumer in such tickets, they are causing a foreclosure effect. With respect to coming back to the Section 4, Subclause 2, Part C argument, it is submitted before the honorable bench that as Fixer is collecting significant consumer data, which entails high costs to be accumulated, and also further high costs to be analyzed. Only Fixer has the requisite ability to collect this consumer data, and whenever any input is very essential to annex competitors or acquire competitors in the market, it is considered as a crucial facility. Additionally, Your Lordship, in the Google shopping case of the European Union, it was held that whenever any dominant entity has a loads of consumer data, it raises the technical entry barriers for newer entrants into the market because they are not able to acquire such data or they are not able to compete with their competitors. The council senses that there is a scarcity of time. The council will be requesting a short extension. Much obliged. With this respect, it is submitted that as the consumer data has a tendency to increase the technical entry barriers, and it is indispensable to acquire more customers in the market or to effectively compete in the market, it is contended that Fixer's consumer data is an essential facility. With respect to the second problem of sales commission, it is
You think the essential facility doctrine, by that logic, then everything is an essential facility.
indeed not, Your Lordship.
An essential facility is something that you cannot live without. This can't be it.
And maybe if I can just add to that question, maybe address A, why and how, on what basis you're going to make up that claim that it satisfies the essential facilities doctrine. Is there any other precedent in a similar kind of situation? Or do all two-sided markets effectively become essential facilities? Also, you as your own business practice, since you seem to be a competitor, are you not also collecting user data? In which case, is there a possibility of you becoming an essential facility as well?
Indeed not, Your Lordship. As per the fact proposition does not state that any other competitor apart from Fixer is collecting consumer data, and the same cannot be construed by the council. With respect to the said President, Your Lordship, whenever any consumer data has been considered as a facility to compete effectively in the market, it has been ordered by the competition authority itself to share such consumer data. Such sharing was ordered in Canada by in the case of Toronto Real Estate Board, and it was also considered in the case of GDF Suez Canal, which is a French competition authority case. And because the consumer data was collected by one dominant entity and was very essential to effectively compete in the market, sharing of such data was allowed and
Parameter of the Indian statute.
apologies, Your Lordship.
French law parameter of the Indian statute.
Your Lordship, as per the firstly to answer this question, as per the proposition stated that social value is taken by the competition.
I'm asking you whether when it is pursued, one has to understand the context in which the decision is done. Is the law parameter or indeed is
Indeed, the European Union CSU is not carrying the difference. It's Indian competition statute has been derived from that itself, and even if relevance is placed on the treaty of functioning of the European Union, it can be seen as Article 102, analogous to Section 4 of the Constitution. In this respect, it is permitted.
this is the data in which we share. So what is your say about the role of the Board of Judicial Regulator in light of the CSA judgment that in case there are certain jurisdictional facts with respect to this fact, whether the data collected is disproportionate, then the jurisdictional fact should be in the first instance be determined by the Board of Regulator and then by the inspector.
Indeed, Your Lordship, answering your question, the Council will be giving a two-part solution. Firstly, it is permitted that whenever the data in the present case has causing an apologies, Your Lordship, is causing an applicable adverse effect by not sharing with the competitors, it is the imperative duty of the competition authority to allow the sharing of this data. And such data sharing has been allowed by foreign jurisdictions as well. Secondly, Your Lordship, as per the proposition itself, it was specifically given to the Council to not argue jurisdiction as an issue or any kind of exception, and for these reasons, that has not been considered.
But I think this is a matter of theory. Would that be something that would be relevant?
Indeed not, Your Lordship, because Pixel has taken consent from all the consumers to share their data with third parties, and its relevance is placed on point number 31 on page 4 of the clarification. It is clearly stated that Pixel shares such consumer data with third parties for every purpose which is included but not limited to research. So such data sharing in the present case is already taking place, and if such data privacy matters exist, then they are in contravention of that law. The Council seeks another extension to
At the same time, can they share social data that they collect with you?
Indeed, Your Lordship, for pro-competitive effects, data sharing has been allowed even for personal data in the
Very
very
convenient.
Yes.
Very, very convenient. So surely they need the consent of the user.
They have that consent, its relevance is placed on the property.
Maybe that's something that could be using to your advantage. The fact that the consumer is so willing to offload all data because he or she gets access to a very convenient service. Something like a very law case for
Indeed not, Your Lordship, because such data is required to provide such innovative services to the consumer, and in the OECD report pertaining to abuse of dominance in the digital market, along with the consumer data protection report of the OECD itself, it was held that whenever any consumer data is essential to give new features to the consumer, and further innovation has been done in the market, then in that case such data sharing can be ordered, and if relevance is placed on paragraph number 11 of the proposition, the last line, Your Lordship. It is contended that whenever it is contended and actually stated as well that whenever an account is created on the digital platform, they take the consent of data sharing with the third party. If I move to wrap up, Indeed, Your Lordship, Constitution Committee one sentence for the abuse of dominance it has tried to establish. Firstly, it is contended that as Pixel is sharing such consumer data at exorbitant prices and trying to drive out competitors owing to the price competition in the market, it must share such consumer data with its competitors at favorable terms. Otherwise, it's in contravention of Section 4, subclause 2, Part C of the Act. With respect to the tying of services, Pixel has leveraged its dominant position in one market to enter into another market, and such leverage is held in contravention of the Competition Act as per the MCX Stock Exchange. It was a pleasure asking you for this. Thank you.
if I might just take a moment to check my report.
council seeks permission to refer to the members of the cell at your lordship. Recognized. The council
Just as individually.
individually at your lordship and collectively at your lordship. Since there is no female members in the consent, I can just collectively refer to them as your lordship. In the present case, the council shall be arguing submissions pertaining to issue number 3 and issue number 4. If your lordships are well apprised of the relevant facts pertaining to my submission, I shall proceed with the submissions.
Why did you start with issue 4?
Indeed, your lordship.
And why is that even relevant?
Your lordship, in the present case, we can observe that the combination between Trickster and Thunderbird is likely to cause AEs in the market and hence would be in contravention of section 6, clause 1 of the Act. Since the informant here was aggrieved by the combination order, it has appealed the same order in front of the order. Indeed, your lordship.
What is your locus to challenge the combination of?
Your lordship, under section 53, clause D of the Act, it has been observed that any person who has been aggrieved by an order that has been passed by the Competition Commission of India shall file an appeal in front of the
If
national.
you file an opposition, was the transaction notified by the CC?
Indeed, your lordship.
Did you file an objection?
Indeed, not your lordship.
I should be here.
However, your lordship, there was also an incident of gun jumping in the present case.
That's not your concern, that's within your limit. So if you choose not to raise your hand at the right time, when you wait to take a chance on whether people approve or not approve, you've gone ahead and granted approval. I should be here.
Your lordship, the
You
order
have
has
stopped.
the order has been passed under section 31 of the Competition Act, approving the combination. However, under section 63 clause A of the Act, it has been observed that if any party has been aggrieved by an order that has been
Guessing
passed,
that you would be aggrieved by a proposed combination. This is the first thing. You are given an opportunity to assist us in addressing that issue. You choose not to participate. In fact, you don't even express a grievance. Why should we even treat you to be an aggrieved person? If you were not aggrieved when the combination was proposed, why should we be aggrieved when the combination has been approved?
Your lordship, the current council can observe that in addition with the current practices of Trickster, the current combination can result in significant foreclosure of its rivals. And hence the
Is there
combination
anything that it is doing today that is beyond the approval granted or beyond what is notified to the commission?
Your lordship, if allowed, the council can substantiate upon the same through several facts.
So I'm going to ask you a very simple question of that. Is it doing something different from what it sought approval for?
Indeed not, your lordship. But it can be observed that when any kind of incumbent firm has a indication of significant foreclosure of its rivals due to the combination itself, the same can cause an AEC in the market. And the council shall be arguing this.
I think the question also is that were you put to notice at the time at which this notice was filed before the competition commission? Why did you wait till the order was passed under section 31 to come on the case? You file an application, send a letter to the CCI, and was there anything that you did when it came to your notice that this combination was first filed with the CCI? And if you did not at that point of time, then why should we be hearing you now?
You want to go fundamentally. This is a matter of process. Are we required to notify proposed combinations to the world at large, inviting objection? Yes or no?
Indeed,
Yes or no?
Indeed, your lordship. But how these facts have been processed by the commission has to be observed by any kind of aggrieved party. And if these process of facts is unsatisfactory in nature, they can file an appeal in front of the honorable.
Also again, sorry, we're going round in circles. You say you are aggrieved. And that is why you say you have the locus to maintain an appeal against an order granting approval. If you choose not to even put your hand up and assist the commission as to why we should not grant your approval to a proposed combination, which means you are not aggrieved when the combination was proposed. Why are you aggrieved today then? Because that combination which was proposed, you didn't get an opportunity. You are not aggrieved, then how can you be aggrieved today?
Unfortunately, your lordship, in the fact proposition, there is no assumption or association as to whether the Kadabra has actually assisted the commission in ascertaining the order passed under section 31. In the present case, the council shall be representing the party in order since they have been approved by the improved order.
Understood. Is there any precedent in your favor or against?
Indeed, your lordship, there were several precedents in our favor, and I should substantiate to the same if allowed by the commission.
Give me an instance of somebody who chose not to participate in the public notice process, but ultimately was held to be in a combination.
Your lordship, the council is not aware of such procedural facts, so immediately. The council shall proceed with issue number 4 since they have reached upon the same. The council shall rely upon 4 factors to substantiate that the current combination does cause an AEC in the market. Firstly, we can observe that the combined market share results in a significant market concentration in the current market. Additionally, we can observe that the combination significant buyer power can result in AEC in the market. Thirdly, it can be observed that the combination results in insignificant competitive restraint and eliminates an important competitor. And fourthly, we can observe that the combination raises a significant barrier to entry. I shall proceed with the first one. It has been observed that when a combination does result in a moderately or high market concentration, any kind of concerns arising out of the combination has to be adequately evaluated by the competition authority. For assessing market concentration, the competition authorities have relied upon the Hirschman-Herfindan index in order to assess if there is significant.
I never understood that. Just explain what that means.
Indeed, Your Lordship, the Hirschman-Herfindan index is an index used for evaluating the market concentration, and the same calculation is made by squaring the market share of each player in the market and ascertaining the amount, the sum of the amount. It has been observed that the index would be, of course, in the range from 0 to 10,000, 10,000 being an absolute monopoly, and 0 being a completely fragmented market with extremely small players. It has been observed that if the index is in the range of 1,500 to 2,000, it can be moderately concentrated. And additionally, if it is in the range of 2,000 or 2,500 and above, it can be highly concentrated. If the combination has resulted in an increase of the index by more than 150 or 200, there can be significant competitive concerns, and the competition authorities shall evaluate this. In the present case, Your Lordship, upon objective calculations, we can observe that the index does come up in the range of 1669 to 2249 with a delta of about 480 to 560. The delta is the increase in combination due to the increase in the index due to the combination itself. This can result in significant competitive concerns. So the XY index is used to evaluate any kind of combination and whether it causes significant market concentration. To address your question, it can be observed that in data-driven economies and in network economies, often significant market power can play a role, whether the certain incumbent firm can cause an AEC in the market. In the present case, the council is not arguing solely on the basis of the HHI index that the combination causes AEC, but it is raising the fact that since there is significant market concentration, there can be concerns with pertaining to the anti-competitive effect. And I shall substantiate through the other 3 factors that there is anti-competitive effect, if I may. It can be observed in the present case that Pfizer has a significant buyer power in the current economy. It has been observed that in distribution chains between upstream markets and downstream markets. For clarity, in the present case, the upstream markets will be the theatres and multiplexes, and the downstream markets will be the booking platform, which facilitates the sale of these movie tickets. In the present case, we can observe that Pfizer's combined market share is up to the range of 38 to 43%, which is the indication of significant buyer power. It has been observed that when a downstream player has significant buyer power, they are likely to obtain favorable terms from upstream players, and if there is no competitive restraint in check, it is not likely that the favorable terms necessarily passes on as consumer benefits. In the present case, Your Lordship, we can observe that theatres and multiplexes are offering favorable terms to the incumbent firms, Pfizer itself, to price parity conditions and exclusivity agreements, which I shall substantiate through issue number 3. It can also be observed in the case of Rev/Men, which is a European Commission case, where sellers have testified.
How many members on that?
Your Lordship, in the European Commission case, it was a 3 members. Who are they? Your Lordship, I am not aware of who these members are. My apologies.
Just one clarification. You said favorable terms expiry.
Your Lordship, it provides favorable terms in respect to the downstream players. As in the downstream players will be able to profit more from the terms, not necessarily the consumers itself. Your Lordship, in the case of View/Men, these sellers have testified that when there is a substantial amount of sales being derived from a certain downstream player, they are indeed dependent on them and hence will have to heed to any kind of not heed, but they will have to agree to many kind of favorable terms. And they have observed that any substantial portion of sales in the range of 20 to 30% can result in a significant dependence from the upstream players onto the downstream players. In the present case, Your Lordship, we can observe that Trickster has a market share of 30 to 35%, which can indicate that several theatres and multiplexes who might derive a substantial portion of the sales through the downstream player will indeed be dependent on them. That is
50% of the market is still offline. How does it matter?
indeed the option, but then they are not selling the same through any other online booking platform, which are the downstream players in contention, and hence the competition can be affected in that market. Your Lordship,
I think just I used to lay down my point. If there is such a large part which is in the offline market, if there is about 70% of the market which is contested with even the online market, is there really a problem here that 30-35% is focused on one player? I mean, this is a highly contestable market by any standard.
Your Lordship, the intermediary services for facilitating sale of movie tickets is indeed a growing market, and hence theatres and multiplexes might find reliance upon the services that have been provided by booking platforms.
That's my problem. The fact that you say might find, opposed to likely to find. There's a huge difference there. Now you're on speculation and conjecture. There has to be at least some fundamental basis to suggest that the effect of this is going to be what you're looking for.
Indeed, Your Lordship, the same can be observed through several cases. For instance, the criminal case of Federations of Hotels and Restaurant Association of India versus Make My Trip, where it was observed that the hospitality sector and the hotel room sector were indeed heeding to favorable conditions to the online intermediaries.
That is challenge.
Indeed, Your Lordship, it has been challenged. Yet the order has not been paid and still has persuasive value before this learns to do. Indeed, Your Lordship. It has also been observed that if the incumbent firm has a likelihood of foreclosing its rivals, an addition of market power through the combined entity might result in an AAC in the market. It was observed in the case of Boeing and McDonnell Douglas, a US jurisdiction case, that several parties, the Federal Trade Commission of the United States.
Is there a form?
Your Lordship, it is a competition regulator in the state of in the country of United States.
Is it a form?
Your Lordship, its value does hold the judgment does hold value in the field of competition law, and hence it can be held upon as a jurisdiction in the court of competition. Your Lordship, the commission also evaluates upon investigates and evaluates upon the practices by itself by often appointing a Director General in the case of the Competition Commission of India, and hence will act as a commission. It also acts as a regulator.
FTC, who investigates?
Your Lordship, you may rephrase the question.
The FTC framework, who investigates?
Your Lordship, I am not aware of it. It was observed in the case of Boeing and McDonnell Douglas that several parties who were dealing with Boeing were not entering into any kind of agreements with the competitors of Boeing. This was an indication of significant buyer power, and they held that McDonnell Douglas were to be combined with Boeing, it can result in an AEC in the market. In the present case, Your Lordship, it can be observed that through the memorandum of understanding between Trickster and various theatres and multiplexes, exclusivity arrangements can arise where these theatres and multiplexes do not sign with other online booking platforms. Hence, it is an indication that the buyer power of the current incumbent firm of Trickster itself can result in a foreclosure of its rivals, and an additional market share of 8% can result in an AAC in the market, and hence the competition could be in conflict of Section 6, Clause 1. Your Lordship, I shall proceed with the third fact.
If you want us to interfere, then you have to demonstrate that it is.
Your Lordship,
If it could be, then there's a plausible view. You don't need to interfere.
indeed not, Your Lordship. If a combination is likely to cause AAC, the Competition Commission and the Tribunal itself can evaluate whether the certain agreement does result in contravention of the competition.
Threshold for that evaluation by us.
Indeed, Your Lordship. Often the competition authorities also rely upon analysis made in foreign jurisdictions where the cases may have been similar.
What is the threshold for it? This is a case where you are saying at the highest it's a 43% market.
Yeah.
which as a result, according to you, leads to the possibility or increased likelihood of consequences in the aftermath. The Competition Commission evaluates it and says, we don't believe that there is a problem. If it was 50, perhaps we may have interfered. But if the Competition Commission is satisfied, why should we sit in, in judgment over it and view for it? Unless there is something grossly wrong.
Your Lordship, firstly, under Section 20, Clause 4, there is a plethora of factors that have to be considered in order to analyze the combination.
To show us that assessment is perverse, or is that the yardstick, or is there some other yardstick? Can we substitute our opinion just because you say?
Your
Not a
Lordship,
lack of substitute. You also substitute of fixed right? That's also a factor here under section 20.
Indeed, Your Lordship.
You are not the only substitute.
Indeed, Your Lordship. Indeed, not, Your Lordship. In cases of countervailing buying power, which is the argument being brought upon here, the question arises if a consumer can switch to other booking platforms in order to buy their ticket. In the present case, Your Lordship, in the combination of PVR/PVR, the consumer behavior of cinema goers were observed, and it was found that cinema goers were unlikely to reach theaters and multiplexes outside the area of 5 kilometers or 10 kilometers within the vicinity. And hence, a switching factor is slightly different in the present case. If a booking platform is able to tie theaters and multiplexes on exclusivity arrangements and their current competition,
Are they having exclusivity relationship with all theatres?
indeed not, Your Lordship. However, imposition of exclusivity arrangements have been placed upon theatres and multiplexes in the present case. We can observe that if these theatres and multiplexes do not sign a memorandum of understanding with the booking platform itself, they shall be delisted of the ratings list in the platform. It has been observed in the case of FHRI versus MMT Go that ratings list is one of the major factors among which the sellers do compete amongst themselves. And if the ratings list itself is not available for the sellers, it can indeed result in a constraint on competition on these sellers itself.
So, Fixer has invested so much money in their R&D, and they come up with certain services which are beneficial to the theatre owners, right? And therefore, the benefits that they are giving to theatre owners, some of the theatre owners, not all of them. Obviously, they would want some sort of exclusivity. So, is it per se bad?
The Lordship,
While
while
investment and collaboration they did over the years, as if the facts suggest, obviously they would want to have some sort of time with the kid owners just for themselves. So what is wrong with that?
firstly, Your Lordship, sorry for interrupting you. Secondly, I shall explain how an exclusivity arrangement between a theatre and multiplex, along with its booking platform, can result in adverse effects on competition. While the council does not concede the fact that Richter does have a superior product or service, if it uses its position in the current market to significantly alter the competition around Richter, it can result in a contravention of the Competition Act. For the same, I shall place reliance upon the case of DMX70, Turkish Competition Authority case. It was observed that an online booking platform was placing exclusivity arrangements on its restaurants when it comes to booking tables. It was observed that when
What is the market share of that platform?
Your Lordship, the interesting fact here is that the market share was below 30% and actually was in the block exemption regulation plan. However, on finding out that the network effects that were arising out of this exclusivity arrangement were likely to cause AEs in the market, it was held that these certain agreements were resulting in barriers to newer entrants and hence was causing AEs.
Was that in the merger context?
Your Lordship, it was not in the merger context. However, the learned member of the bench was asking me, the Lordship himself was asking me that whether how exclusivity arrangements between theatres and multiplexes between the platforms can significantly alter competition, even if they have been offering superior products or services for the same service.
So Council, I think the key point over here is that point us towards the efficiencies or lack thereof, which are specific to the transaction at hand. If a problem could have existed when the company was at 35%, why would that have changed now that they have acquired an additional 8%? Our jurisdiction under Section 31 is limited to looking at that specific question. This is not an antitrust investigation. This is a combination that we're evaluating. So unless you can demonstrate that that additional 8% that I have purchased or that the company has purchased is actually causing an appreciable adverse effect in competition, I am not inclined to engage.
the Lordship brings upon an important condition as to whether the current competitor being eliminated through the acquisition results in an A. It brings to my third factor, which is that there is insignificant competitive restraint and the current combination eliminates an important competitor. While the 8% might seem on the basis of arithmetic itself as insubstantial, we can observe that it is the third largest player in the current market. Additionally, we can observe through the list of clarifications itself if the chips can place relevance upon point 22 in page number 3. We can observe that Trickster provides a personalized section of movies and other events based on its booking history. Hence, it is giving some sort of a consumer recommendation which is similar to Trickster itself. Hence, one of the few competitors that has been competing even on non-price factors with Trickster is being eliminated through this acquisition. And hence,
what Trickster is doing is nothing new. I mean, you have this facility available on every second platform. I find it strange that you are effectively not providing something that is standard and part of the course. And then you can convince the fact that they require somebody else with an 8% share, and according to you, 8% is significant. If 8% is significant, then 5% is also very valuable. There are multiple 5% players.
In the present case, we cannot ascertain how many 5% players are there. However, every market player, other than the three major players here, is below the market share of 5%. In the case of Rand-Baxi combination, it has been observed that market players who have an insignificant market share are unlikely to cause a competitive restraint upon its combination, and hence it cannot be calculated into the competitive restraint factor. In the present case, we can observe that through the elimination of the competitor, there exists only one major competitor, and there is no other significant competitors in the present case. And hence, the combination can cause an AEs in the market in addition to its current practices. We have to also ascertain the current practices in order to ascertain if the combination can cause AEs in the present case. So, Lordship, that brings me to my fourth factor. Oh, my apologies. My apologies for Lordship. If I may just substantiate upon one factor and the price parity process, the answer will be much obliged for the same.
I think you want to answer the question.
Oh, the
Lordship is asking you to come to the prayer.
indeed, but once I receive my prayer, will I be able to substantiate upon the rest? Indeed, Your Honor. I shall bring myself to the prayer in the present case. Wherefore, in light of the arguments advanced, the issues raised, and the authorities for indeed, Your Lordship. Firstly, can we observe that if this tribunal does find that CCF has erred in dismissing the allegation, they can do one of the two things that is possible. Firstly, they may direct the Competition Commission to re-evaluate the practices and, in fact, order the Director General to investigate into these practices themselves. Indeed, Your Lordship.
Not ask for it.
What you have asked, I am on platform. You know our power, and what we can do or what we cannot. The question is, have you asked for that?
Or is it in that italicized question of your prayer? It could be, I don't know. Look at it.
Your Lordship, in the prayer of the italicized fast, we are praying that this tribunal does take any order in light of justice, equity, and good
I
conscience.
would say that like the drafting that you everything and then you have one to just have the Italian science course.
Why don't you take 1 minute to answer other question? You wanted to address that other right side.
Firstly, I shall substantiate the factor of barrier to entry in the combination. It has been observed in any kind of.
I think we should have to skip over that. I mean,
That's all right. That's all right. Thank you, Dr. Thank you.
So I shall proceed with the price parity process.
Thank you.
One is representing CCF and another is representing no, you all are
No, no, we are responding for picture and picture.
Both.
Yeah.
Both.
both you are coming from
I know.
CCF is here. The council is also representing the standard people.
You're not good. Before the appellate.
So now that asks you to
Join the
join the fence.
Sorry, I have not access to people. So, sir, please.
Am I audible? Good morning to all present here in this honorable activist tribunal. My name is Anshuta Devnath, and I, along with my co-counsel, Ms. Aditi Sinha, will be representing the respondents in the case titled Ida Kadabra versus Fixer and another. With the permission of this tribunal, may I refer the members individually as such? My pleasure. At the outset, I would like to clarify that I will be speaking for the next 90 minutes on the first and the second issue. The first issue being the abuse of dominance of Fixer by time and leveraging, and the second issue being the abuse of dominance, the denial of market access. We are representing Fixer and the Competition Commission of Province.
Isn't there a conflict of interest? Now we know how you approve the process.
Yes, sir. But the tribunal here has been fixed to club the two appeals, and accordingly, the commission, the parties involved responding have.
There's no problem with sorry, absolutely. How does the same council represent the regulator and the person whose approval is sought?
Yes, sir. In the present case, the commission does not believe that there has been any problem
That
from
is
their part.
precisely the problem. The fact that you don't have a common lawyer could be a complete abdication of your responsibility.
Yes, sir. But how will you show?
But for a regulator to join a private party to come up with negotiations.
Yes, I understand your concern. However, to the
They
court.
have no concern. The concern will be expressed if and when they have to. But right now you have a very thin line to walk on.
Yes, sir. To
So
the
tell us
court.
why you argue for first. CCI or the Fixer or both?
Thus, to the course of our submissions, we show that how Fixer conduct.
I'm still trying to understand. Who are you arguing for? Are you arguing for Fixer or are you arguing for the CCI? You tell us which hat you are wearing for now.
We will be arguing for Fixer conduct, showing how its effect has no effect on the competition there has been no distortion of the market. We shall be showing this on behalf of Trickster, and then we'll proceed to show how the commission has not earned because there has been no distortion of the competition in the market. Proceeding further with the structure that I was clarifying, my co-counsel then proceed in the next 19 minutes on the third and the fourth issue. With the permission of this tribunal, we have reserved 2 minutes for Sir rebuttal. Is the panel familiar with the brief summary of the facts, or should we?
What according to you is the single most important fact?
The single most important fact is that Trickster and Idrakadabra are on the same playing ground in the market, and accordingly, Trickster is not dominant in this market. And even considering that it is dominant in arguendo, its conduct is not abusive in nature, because every step that it has taken is to sustain in this dynamic market. It has tried to innovate and sustain to ensure the competition remains in this market.
With the first point that you made, how do you say that Trickster and Idrakadabra are actually at the same space?
Yes, sir. Proceeding to my submission, I will show that Trickster is not dominant in the relevant market level. In the
I'm sorry, I'm asking you to tell me why do you say they are essentially at parity?
All right. So proceeding to that, Trickster is not dominant in the relevant market. Firstly, we'll be using section 19.
Again.
Yes.
How are these equally placed? Let's start with that.
Yes.
Okay, dominance.
Yes, sir. So
So
in
the minute you start going down the dominance path, I mean, I would presume that you are effectively dominant in the trying to tell us to now look at it differently.
yes,
Since
I,
you've now gone and made the point that they are essentially identically placed, tell us why and how.
yes.
And what are the parameters you use?
So firstly, let us consider the market share. The market share of Trickster has been delineated in the proposition of 30 to 35%. However, in the market that we operate in, that is the market for the booking of movie tickets included. Every channel through which we can buy tickets is the relevant market. In the present case, accordingly, if you refer to page 1 of volume 2 of our compendium, there we have shown through pie charts how in the market that we have delineated, because that market is inclusive of multiplexes as well, box office sales as according to the Moot proposition, in that case, Trickster's share automatically shrinks. So Trickster's market share is, let us consider, has shrunk from 30 to 35% to 20%. Accordingly, Idrakadabra's share must also shrink. And this small market share is not enough to assert market power. Proceeding further, let us talk about the economic resources that is present with both the entities. It has been already admitted by the appellant learned counsel that both of these are strong players. Idrakadabra is the second largest player in the market. Now, clarification 21 states that both have high EBITDA, that is, both have high earnings. Moreover, both have reached a valuation of 1 billion in the industry of clothing because they have been termed as unicorns. So this shows that both of them have a level playing ground when considered economic standing. Further, in the e-commerce market study that the Competition Commission released, paragraph 51 states that online platforms have a very low switching cost. That is, if consumers are not happy with one platform, they have every right and they will shift to another platform. So this shows that Idrakadabra and Trickster are operating on the same playing field, and that any moment there is a very likely possibility that consumers will shift between the two. And finally,
I'm sorry, can I interrupt you for a moment? The pie chart is interesting because it seems to suggest that there is a falling number of SKUs, number one. And number two, you say that there are at least possibly very low switching costs. Do you have any evidence, or is it purely speculative of this so-called multi-homing? That people who are booking tickets are using more than one platform?
yes, sir. It's an established practice. I derived this from the e-commerce market study, which is a good study of how the market functions. So in the present case, we find that with respect to your second question, switching cost is established when there is ability of the consumer to shift between two platforms. Because online platforms function in this way that consumers are very, very specific on what they want. The moment the platform is unable to deliver on their promise, they can easily switch. And therefore, I talk about how online platforms have been switching. Now, with respect to the first question, when we spoke about the pie chart, that is with respect to the relevant market we have delineated. The relevant market of delineated is the market for the booking of movie tickets included. Whereas the 30 to 35% of market, as mentioned in the Moot proposition, is on the online ticket booking industry. Since in this market we have also included the box office sales, accordingly, using normal mathematics, the
If you're comparing apples and oranges, I mean, they are two completely independent markets. And that seems to be the position that your client, the CCI has taken. So, CCI. the assessment of the market. Is that how the CCF is proceeded?
Yes, sir. In regards to our case, the CCS has believed that the case in question necessitates that the market be delineated as the booking of movie tickets. Because the fact
Why
that,
should the CCF be allowed to adopt different yardsticks in different markets?
yes, sir, because it's the facts and circumstances of the case that will determine. If we refer to paragraph 8 of the Moot proposition, page 3, paragraph 8, line 3 to 4, there it is specifically stated that Trickster is competing not only with other online booking platforms but as well as box office sales. This shows that in the market of clothing, the competing entities are not only online channels but as well as offline channels. This shows that when two products are competing in the market, consumers perceive that they are substitutable in nature. That is why there is a reasonable apprehension within the minds of this product that there is a very good chance that consumers will shift to a different platform if we are not being able to deliver. And accordingly, we see that competing products are necessarily substitutable. And so we have delineated the market as such.
On this market study, since you refer to the argument of multi-money or consumers looking at different competition. But in e-commerce study also issue an advisory to the platform for not indulging in the
Yes, sir. And to the course of my submissions, I will show that we have complied with all standards that are in this industry, and we will show that there has been no anti-competitive practice. So, given the factors that I listed out with respect to market share, how Ibrakadabra and Trickster are on the same playing ground, I would like to quote Meru Travel versus ENI Technology, paragraph 43, where they have specifically stated that if there are two strong competitors in the market, no entity is dominant in that relevant market. So accordingly, Trickster is not dominant in the relevant market that we have given. Is there any questions with regards to this question of dominance?
I think we should proceed.
Yes. Proceeding further, whether Trickster has abused their position of dominance. Abuse of position of dominance occurs when an entity is dominant. We have already stated that Trickster is not, but in arguendo, we will also show that the conduct is not abusive in nature. It has been alleged that we have been indulging in time of services. But the very essential of time is that there must be anti-competitive foreclosure of the tied product. In the present case, if you refer to clarification 29, it has been stated that Trickster exclusively uses Rodeo, the product that has been alleged to be tied in. So this shows that Rodeo is not available throughout the entire market. It is available only with Trickster. So Trickster's integration with Rodeo is just an innovative business model that we are presenting to ensure that consumers have a seamless way of transacting and ensuring that their experience is much more better. The market in itself is extremely dynamic, and we have to.
Explain that to me. What is so special about Rodeo?
Rodeo has been providing cashback schemes to its consumers. Further, again quoting the e-commerce market study, paragraph 53, there it is stated that it's a standard industry practice for online platforms to develop in-house brands so as to make the transaction process much more secure, much more seamless. Indeed not, sir. What we're trying to establish by quoting the market study is to establish the dynamics of how this market
They
works.
don't even quote it. That's the question we're asking.
Yes, the Competition Commission, when they have brought this market study, is to understand the competitive concerns that might arise when certain conduct is taking place. We are deriving our analysis from that to show that there is no competitive concern that is arising. So proceeding further, there are multiple benefits that we are providing to the consumers with respect to the time. Further, Rodeo is a very new entrant in the market, and this fact is facilitated with the fact that it is not available anywhere else. There are already established.
That's the problem. So a new entrant suddenly gets access to a substantial share of the market by this arrangement, whereby you are expected only to deal with Rodeo.
Yes,
Is that something that is permissible?
yes, sir. In the present case, it should be allowed because Rodeo is not being able to affect the market as a whole. So we are not essentially affecting the market or the competition in the market. There are already established players like Toggle Pay, Bill Pay, etc., as mentioned in the fact sheet. And this shows that we have not have the ability to drive out. With the launch of Rodeo and the seamless integration with our process of selling tickets, we are simply testing the waters out and checking whether consumers like it. And we have seen that consumers have marveled. Florist population has marveled on how much they like our product and they want to use it. So there has been no complaints from their side as well. And accordingly, we are not disturbing competition, nor are we limiting consumer welfare.
The average consumer doesn't have the time or the energy to spend time on time. He or she does what he or she believes is convenient. We are looking at it from a macro perspective, and in fact, that's what top clients are looking at it expect to do. We are looking at the market from an overall perspective, not from an individual perspective, and that seems to be where the disconnect is.
Yes, sir. With respect to the macro perspective and whether the competition as a large and the market as a large is being affected, as I have submitted, that according to clarification 29 of the proposition, Trickster exclusively uses Rodeo. That means Rodeo is not available anywhere else in the market. So it imposes no competitive constraint on any online payment application, and therefore the market in question does not even arise. We are simply using it along with Trickster.
The problem is that other competitors of Rodeo, they don't have access to your platform, which is Fixer, which has around 5% market share and post the acquisition to be around 40%. So your Toggle Pay and other pay, they will not be able to have a presence on your platform, which seems to be an important platform. So how do you justify that? Plus, moving from a voluntary to compulsory use of Rodeo, if it is so efficient and so popular, then what is the reason of obligation, creating obligation on the company?
With respect to your first question, that Trickster does not make themselves available to other online payment or applications. As stated earlier, we are simply testing the market to check whether our application, the wallet-based application that we have launched, such as Rodeo Pay, is something that consumers prefer. In future, if we do plan to enter the entire online market, we will ensure that we are not disturbing competition. This is linked to the second question, that why we are making it compulsory. We are making it compulsory because we have integrated it with our application. It's a wallet-based app. So it's so very much easy for consumers to make payments through our application. There are a lot of pros and cons that we have judged, and we have seen that making it mandatory and making it ensuring that consumers are asked to pay through this application is benefiting the consumer, and we have received positive feedback on the same. This brings me to the end of my submission with respect to issue 2. To conclude, I have shown that Trickster is not dominant in its own relevant market, and in argument its conduct is also not abusive in nature because Rodeo, as a new entrant, has no ability to foreclose the market. This was on behalf of Trickster's product, and then
What weight would the CCF?
this is what the CCF observed as well.
What is the role of TCS in an appeal? If you see the issue of what is via the ruling of the Supreme Court, the TCS is only a proper party. Only the cases which are taken pro moto it is a necessary party. But we try to understand with a view to defend your order, doesn't sound like the role of an adjudicator. You are more partisan, particularly you join a private party. There are some big doubts in our mind.
Yes, I understand your concern.
But you adjudicator, you discharge a adjudicator function.
How is it issue?
The form of the matter where we need your assistance of a party. Of course, if any reports are required, we can summon those reports. But the way you are going, defending the conduct of, I think we are not comfortable.
Yes, I understand your concern, but it was from the prerogative of the applicants who thought it fit to join us within the appeal, and therefore we voted.
You could have stood up and essentially engaged somebody to say, I have no room, done my bit, my order speaks for itself. Why would you do this?
Yes, sir.
That's disconcerting. The fact that you engage the same counsel with respect to Fixer is a fundamental problem.
Yes, sir. But we believe that the issues are pertinent because at the end of the day,
Issues are pertinent. The point is how to present those pertinent issues in a proper way. As a counsel, you are an officer of the court, and you also can make a fair submission. But yes, we will engage another or we will not do anything on merits except
see an apparent conflict. However,
You don't see a conflict.
if I would like to substantiate my answer on this regard, in the present case, we see that there is a very crucial question of competition law that is involved, and we are simply trying to ensure that the right approach is taken so that overall
Has the CCI applied the Competition Act correctly?
we believe that the Competition Act has
It
been
has, yes.
it has.
The matter is there. You don't need to debate it after.
You just mentioned a question of competition law in India. Forget about the merits, dominance, and everything. You just mentioned why you wanted to do that. But question of competition, what is that question?
Yes, sir. Before I proceed to the question, may I ask an extension to 3 minutes? Yes. The preamble of the Competition Act states that the primary goal of the Competition Commission and the competition law of the country is
Please formulate the question.
the question of competition is to protect competition in the market and consumer
Now
welfare.
that's the object. What's the question?
The
Can
question
a
of,
person with 15 to 20% be deemed to be a competitive constraint? Can a person with 30 to 35% be a dominant? What's the
the
question?
main question that we believe is pertinent one is that whether should innovation be penalized in the market? Everything that Trickster has done, even as an entity, has the right because it's just trying to innovate in the market. And this, yes, I understand your concern, but we'll show with the next issue how. Yes. Do I have permission to proceed to the second issue?
Yeah. We have 2 minutes.
Yes, I should summarize as fast as possible. In the
2 minutes.
yes, with regards to the second issue, I have already shown that Trickster is not dominant in its own relevant market. In arguendo, it has also not denied its market access, primarily because the data that we are collecting are the demographic information that is widely available. Markets as of such, like online markets, cannot exist without the collection of demographic information like name, phone number, etc. For example, anytime you download an application, the first thing they ask you to do is enter your name, you put in your email address, and immediately you get emails about verification. So this is something that is a standard industry practice and everybody does. And most pertinently, this data cannot be considered to be an essential facility on the ground that this is not essential to access the market. This thing is available to everybody, and we are not preventing anybody from collecting the thing. I would like to quote Asia Railways versus Ministry of Railways 2011, wherein in this case, the essential facility doctrine was discussed. After immense arguments about whether infrastructure was considered in that case to be essential, at the end, the Commission held that because the entity was not preventing anybody else in the market from collecting the technology, it could not be considered to be an essential facility. It has been alleged by the appellant side that we are charging exorbitant rates, but that is just an allegation. We believe that with our investments in this market, the rate is absolutely fine, and that we are completely, as a business entity, have the right to protect our commercial interests. Yes, sir. But these allegations do not stand because of what we are promoting, and that is innovation.
What is the threshold for an investigation?
There must be substantial evidence to show that.
Sorry, where are you getting that?
This is an administrative order as per the State of Jodhpur, India regime. Like administrative order.
Sorry, where are you behind that? Where are you getting the yardstick of substantial evidence?
That there should be substance in the evidence to show that there is a.
Counsel, now you're playing with words. What is the threshold for the 26 on order?
For 26 on order, there has to be substance in the evidence that there is a possibility of a violation of the act.
Do we need to use the other side at the stage of 26 1? Because Panama this year, if we have a look at the and with the applications of again, the potential violation, should not that be
Yes, sir, but that is exactly what we are contending, that the Commission of Flooring has already dismissed the prima facie case because they do not find any substance in the evidence.
If the inquiry on a 19 to 26 stage, the same as a section 560. Is the nature of the inquiry similar?
The nature of the inquiry is not similar because with respect to the first stage, with respect to the first stage, it is with respect to whether they find a prima facie case and the same is directed to the Director General. On the other hand, with respect to combination order, the Commission determines on its own whether there is a possibility of a prima facie case, and then they move to second
What's
stage.
the fundamental difference? There is hardcore data that is collected in the first instance, whereas in the second it's really a broad assessment.
Broad.
Right? So you choose to close the hardcore data collection mechanism and use this very convener group who allowed and approved the transaction and then have the same lawyer defend me.
Yes, sir. This is in regards to fourth issue which my co-counsel will address.
Thank you, counsel.
Sorry, just one last question, if I may, before I leave, let you go, which is that what would you, in one sentence, how would you define the doctrine of essential necessity?
Yes, sir. To answer your question, an essential facility is a facility absolutely crucial to access the market and without which no entity can thrive in the market.
Is that it?
Yes.
Where do you get that? Where do you get the
This
receipt
has been
from?
stated in multiple cases.
Name one.
Arsha Railways with the Ministry of
Just give us the exact formulation and answer.
Arsha Railways talk. This is exactly what it is. There is another case in this regard, Shamsher Kataria versus Honda CL, wherein again they have stated that essential facilities are those which is absolutely crucial to access the market and which has to be feasible to be available to everyone at a reasonable cost. We believe that the cost that we are selling is reasonable according to the essential facilities doctrine.
Anyone can replicate it, right?
Yes, the data that we are selling is the consumer data.
So it might be essential, but if it's easily replicable, it is essential.
No, that is what we are contending, that the consumer data that we are collecting.
Thank you, counsel. I think that is the point I was making in your favor.
Thank you, counsel.
Do I have a like to conclude? Thank you. It was an honor arguing before this tribunal. I ask my counsel to now take over. Thank you. Am I audible? Good morning, Honorable. Good morning, Honorable Tribunal. I am Aditi Sinha and I am the co-counsel representing the respondents today. Over the course of next 19 minutes, I shall be dealing with issue number 3 and issue number 4. Issue number 3 deals with the dismissal of allegations that was imposed upon Trickster regarding imposition of unfair conditions. Issue number 4 deals with the approval regarding the combination that was granted by CCF. With the permission of this tribunal, I would like to proceed with the submissions for issue number 3.
Ask him to start with issue 4, why did you complete?
Definitely, sir. In the present case, the appellants have argued that there is a likelihood of AEC to be caused under Section 20, subsection 4 of the Act, and therefore the combination should not have been given the approval. In the present case, as already pointed out by the panel themselves, that we notified the combination on 15th November, as mentioned in the paragraph number 21 of the Moot proposition. And further, the CCF themselves took time to investigate the matter, and wherein they found that we did not notify, that Trickster failed to notify something, they issued a show cause notice. The fact that they issued show cause notice, so
Let's not talk about the fact. How about you come to Section 20
definitely.
and explain which of the factors are in your favor? Let's just assume that they had the right.
Definitely.
What are the factors that you would argue in your favor, which sort of say that combination does not include?
Coming to the factors, there are several factors that have been laid down. We shall be going on them one by one. The first that they contended was the decrease in the countervailing buying power. In the present case, if a combination is taking place, it is very reasonable on the part that one competitor is going to be acquired by the other in a market. That does not necessarily mean that the countervailing power is decreasing. There has to be a substantial decrease. We shall be showing that in the present case, Ibra Kadabra themselves is preferred by 15 to 20%. I would like to draw your attention to the word preferred. It does not mean that the market share of Trickster is restricted merely to 15 to 20%. The paragraph 9 of the Moot proposition, if you may refer to that, in the line 4, it states that 15 to 20% of people prefer Ibra Kadabra over Trickster, which means it also has certain efficiency that makes the consumer prefer them over us, despite us providing such efficient facilities to the consumer. Thus, the countervailing buying power of the consumer is not being hampered, because the moment we as an entity fail to provide services that is satisfying the consumer, they are preferring Ibra Kadabra over us. Therefore, the factor of contention of decreasing of countervailing buying power does not stand. Further, moving on to the next factor, there is no substantial increase in the market share. And how do we say that? If you may refer to the first page of the compendium, as we have shown in the pie chart, the market share of Trickster in the relevant market that we have determined decreases from 30 to 35%, which means the market share of Thunderbird will also decrease from 8%. It no longer stands at 8%. Supposedly, if you may refer to I think I sense a concern from the panel. Yeah, proceeding to the submission. Since the market is expanding and the market share of Trickster in the market that we have contended, that is booking of movie tickets, is decreasing from 30 to 30%, and the market share of Thunderbird is also, as mentioned in the Moot proposition, is with regards to the online movie ticket booking platform. Therefore, when we see the relevant market that we have defined, that is merely the market for booking of movie tickets, the 8% will also decrease. Which, if just for the sake of argument, if we assume it's 5%, a mere increase in the 5% of the market share cannot be said to be a substantial increase, and specifically in a fact where the market share of the applicants themselves could be more than 15 to 20%, because the through Moot proposition does not clearly specify the market share that applicant enjoys. It merely states that the 15 to 20% are preferring. Thus, they cannot contend that there is substantial increase in the market share. Therefore, this factor also does not stand. Moving on to the next factor, that is the creation of barriers to the entry in the market. We believe that this combination is not resulting in any barrier. At max, we are providing better opportunities, better facilities to the consumer. Now, this is essentially for our commercial benefit, that we want the consumers to have the best output in the market. If you may refer to clarification number 19 of the Moot proposition, it states that the industry is growing at a rate of 7 to 9%, which means if any industry is growing, it is likely that the new entrants in the market would like to enter the market. And if they have innovation which they can provide to the consumer, there will be investors who are willing to invest.
Give us an example of an industry where the landscape is somewhat similar to what you are suggesting, and a new player came and disrupted the landscape.
So, for example, let's look at the dating app industry. In 2014, there was Tinder, which was launched in India. And for 4 years, there was no other entity. It was merely Tinder who was operating in India as a major player in the market. The moment a new entrant, that is Bumble, came up with an innovation that now I will provide a facility that only women can initiate the conversation. This shows that at present, 80% of the women go and prefer Bumble. This shows that a new entrant, the moment they come up with an innovation which is able to garner the consumers towards themselves, they can very well come and become even a more important player than Tinder themselves.
So what was the market share of Tinder? What happened to the market when Bumble came?
Definitely, sir. We do not have the exact number of market share, but in 2014, Tinder was the only major player that was existing in the dating app scenario. And in 2018, Bumble was introduced in India. So even in the course of 4 years, there was no other competitor, at least dominant or strong enough to give competition to Tinder. And when a new entrant like Bumble came into picture, despite the fact that Tinder enjoyed dominant position, it was able to penetrate the market. And at the present moment, 80% of the female consumers prefer Bumble over Tinder, which means that the moment we went through the market studies and therefore we came here. Which means that the moment you come up with a new innovative model in the market, you can easily break through the market, irrespective of the market share that an entity enjoys. Therefore, the combination in the present case.
Very recent example of an innovation which is happening existing here in the digital space.
I would come back to you regarding the same in some time. I require some moment to recollect the example.
And sounds like you make an interesting point, which is that it seems from what you're saying, market share doesn't matter. In which case, is there some other conceivable reason as to why do you make this acquisition? You are already at 33-35% of the market. You bought a player who obviously does the same thing as you, right? Is your strategy to buy it and to give it up?
Definitely not. So we, as a commercial entity, just wanted to expand the business, which is well within our rights.
So you were buying it for the market share.
The market share is relevant.
Definitely not, sir, because we, as a consumer, as the
Who's investing in
yes, yes, we as an entity are specifically providing GPS-enabled real-time updates. We wanted to use the algorithm that Thunderbird also has to diversify the services that we are providing. Therefore, the acquisition was merely for commercial purposes and not for the market share only. Moving on with the next submission, they have also pointed out that the
It
likely,
is actually a strategic investment.
definitely, sir, as a commercial entity, we have the right to expand our business with the services that we want to provide to the consumer.
It is a strategic investment and you are buying 100%. You should have notified it in the organization.
So we did notify on 15th November 2022, and on 18th November on 15th November 2022 we released a press notice, and on 18th November 2022
You consummated the transaction before approval was granted.
definitely not, sir. That we notified that back to. We just said that we are entering or acquiring Thunder, but we did not consummate the transaction. We notified CCF regarding the same, after which a due diligence was taken place by CCF themselves. Because as we see the facts mentioned, they found some problem in the due diligence part. They issued a show cause notice, and even after the show cause
Why
notice,
would you get a policy A if you did not jump the gun?
so the fact that there might be certain negligence, we submitted.
So that we are clear on that. Did you gun jump? Did you not gun jump? As a matter of fact.
No, sir, we do not believe that we gun jump. There was certain negligence that I believe that was not appointing to gun jumping.
There is an order of the Competition Commission under Section 43A, so this is beyond belief now. So it's not going to conjecture. What is
Sorry,
sir?
is the policy order?
No, sir, we did not. Because we did not want to engage in further litigation as we had already been granted the approval.
Okay, you only one lawyer. You could have got the same lawyer to handle it.
Definitely, sir, but that was the discretion of the client.
But can you clarify what was the facts?
Yeah,
For
exactly.
what?
Just so that you are clear in terms of how this played out. So there's something very dodgy.
Definitely, sir. If you may,
Counsel, to make your job a little easier, can you specifically say, can you tell us what the legal standard is under Section 43A of the Competition Act? Why you fail to admittedly comply with that legal standard on the basis of which a penalty was imposed? Gun jumping may or may not be relevant, but that's for you to tell us. But tell us what 43A requires, or why the penalty is imposed under 43A, and what your conduct was the result of which you got paid.
definitely.
You're telling us it was not gun jump.
Definitely. So for 43A penalty to be attractive, there has to be non-disclosure of certain facts. However, in the present case, Trickster had notified the business transfer agreement. We did not specifically point out to the clause of which talked about prior intimation and consultation, which was a part of the BTA in general. The negligence on our part was that we did not specify that the clause is mentioned in the BTA, which the commission found to be something to be a negligence on our part in terms of due diligence, and therefore we were penalized. However, the fact that when we submitted a reply to show cause notice also shows that the commission was conscious enough to look into the details, and only after that an approval was given. This shows that the commission themselves had followed the due diligence, and they did not find any problem regarding AEC. And additionally, yes, sir.
Counsel, please look at the provision, Section 43 of the Competition Act. Is there anything over there which speaks about or distinguishes a negligent act from a parent act from an error, parent of the case? Where are you getting this term negligence? What is the
Definitely,
legal standard under Section 43?
it says that if a person fails to give notice to the commission, that is exactly your point. Therefore,
Sorry, that is the commission may. It says the commission can.
definitely, sir, and therefore they imposed a penalty on us. However, we did not intend to gun jump. This was merely a fact that we were negligent enough. Therefore, we did not even contend 43A because we very well understand perspective of commission as well.
Now, if you read your facts carefully, what you are trying to do is that before even the acquisition, you are trying to ask Thunderbird probably to get that payment space that you have. Maybe give them the direction, as well as you also wanted to direct Thunderbird how to list their businesses in multiplace. These are the two conventions that the other side is making. So you did not, so you imposed certain restrictions on the target before even consummating the transaction, which are directly related to the matter, which is including the payment as well as how to list multiplexes, which is the other point about it.
Yes, sir. However, the wording prior to those says it is prior intimation and consultation. It does not mean that we have any directive control over them. They can come to consult. There will be negotiation and discussion. This does not say that we're enforcing them or imposing our belief that you have to use rodeo or other digital platforms. Additionally, this has not been executed as of now. It was a business transfer agreement that has been notified. If the approval is given, we should then follow this business transfer agreement. And therefore, it has not taken effect in the current market.
Thank you, counsel. So what provision will be violated? What provision of the Competition Act requires you not to give effect to the contract?
Sir, we are not supposed to gun jump 43A as mentioned. The gun jumping basically means that we are
What is the substantive provision of the Competition Act which requires you not to give effect to the terms of a combination?
Section
43A is
six.
the Constitution. Yeah.
Section 6.
Can you tell me exactly what?
Exactly. So basically, Section 6 is a standstill obligation, which essentially states that until the approval is given, the competition should continue to exist, which is happening in the present case. The standstill obligations are not being violated. If the panel is satisfied, shall I continue with the submission? In the present case, we have sufficiently shown that the factors that the appellants have relied to show that there is AEC in the market with respect to combination does not stand. And therefore, the approval given by CCF in the present case is right because not only there is no AEC, additionally, they have taken the due diligence also. They have issued a show cause notice, they found no problem with the combination, and therefore they went ahead with the approval. This proves that both Trickster and CCF in the present case are correct. Moving on with the submissions regarding issue 3 of the Moot proposition. Issue 3 talks about imposition of unfair conditions. The learned counsel for the applicant themselves have contended it under two folds, that is section 3(4) of the Act and section 4 of the Act. For coming to section 3(4), in order to cause AEC under section 3(4), the first requirement is that the entity must have enough market power to act independently. In the present case, as we have already submitted, the market share of fixtures will come down from 30 to 35%. Additionally, there is the possibility that Ibra Cadabra itself enjoys a market share which is much more than the respondents themselves. Also, they have equal footing in terms of economic resources. Thus, we submit that our client, that is Trickster, does not have independence to act in the market on its own. It has a strong competitor present in the market. Therefore, section 3(4) cannot attack. Additionally, to show that even if we believe that Trickster enjoys market power, there is no AEC that is being caused under section 3.
Counsel, just one quick question. Where did you get the definition of act independently or the competitor?
So the market power has been defined in the EU glossary from where we have derived the definition. Because there,
Is there a yardstick for the Q4 assessment?
yes, sir, in the case of Automobile Dealer Association versus Global Automobiles Limited, that is a 2011 case, the CCI in paragraph 12.10 said that in order to cause AEC under section 3(4), an entity must have market power, and therefore we are using this.
When AAC, we determined that the prime states without any mystery.
So there has been.
It is not an intuitive exercise. You just can't say based on some trading that it has caused or not. There is some empirical validation by the surveys and other market instruments to use. Prime states, how do you?
So if you may refer to paragraph 19 of the Moot proposition, it states that the CCF themselves had given an opportunity for hearing from both Ibra Cadabra and Trickster themselves. Since both the sides were heard, the CCF themselves had looked into the matter. It is not merely on an intuitive basis, but a reasonable discussion and hearing of both the parties have taken place.
The parties they do not constitute the entire units of market. These are ingrained into the global possibilities. These are not adversarial in this between A and B. Essentially, they are doing market correction. So these two parties they cannot determine much less the under arbiter their outcome of their proceedings.
Definitely, sir. But when Ibra Cadabra is alleging that we have caused AEC in the market, they must have come with certain factors which shows that the market in general is being affected. The fact that they did not have substantial, leave alone substantial, did not have even the evidence to prove a prima facie case, shows that in the present case we do not cause AEC in the market. Therefore, we are contending that there is
Sorry, I mean, you are applying to yardstick. The fact that you did not pause eventually in the second issue. The guest is really speaking at the time when the information is before the commission. What is the yardstick to be applied? Is it capable of pausing? If it is, then an investigation accordingly.
And if I need to say something about that, it says no agreement which causes or is likely to cause. So, hence it is said in the case of certain allegations that there was no even potential to cause any accusation. Forget about actual harm to competition. And it is said with so certitude that in a remote possibility you have after it is an investigation. Like later, like still maybe there can be a closure after investigation.
so for investigations. Firstly, the commission has to be of prima facie opinion that there is AEC that is likely to be caused in the market. In the present case, the applicant was not even able to satisfy the commission that there might exist a prima facie case of AEC.
There before I just testing that. You forget the case for a minute as a matter of principle. If the facts demonstrate that the only other competitor is now no longer in the market and all the others are very clear, is there something that at least warrants an inquiry as to whether this will be case? Because according to you, the nature of the inquiry under a 19 to 26 assessment is very different from a 6 assessment.
Definitely.
Why should an empirical investigation not be done? What's the problem with an investigation? Why are you shying away?
So again, as mentioned, for investigation, the commission must be in a prima facie. We do not find anything that the commission did not find anything that would satisfy that
Let's step back. What is the yardstick for determining whether a prima facie case is based on?
that there is a possibility that the competition in the market is getting distorted. In the present case, it is not being distorted, and that is exactly what our contention is.
Assuming there were 4 players in the market
Definitely.
and one has been acquired by the other, and there are only 3 players, and as a consequence of it, the biggest player today has a 40% market share. I'm not saying 43, say 35% market share. Would that not be enough to at least warrant an inquiry as to whether that could lead to the possibility of 35 becoming 50 in the next 2 years?
So the fact that every combination will result in elimination of one competitor in the market. If pre-combination there were n competitors in the market, post-combination there will be n minus 1 competitors in the market. The mere fact that one of the competitors is being removed from the market cannot be a yardstick to judge that there is anti-competitive effect. In that terms, all the combination will then be termed as anti-competitive. Proceeding with the submission.
Actually, Council, I have a more basic, fundamental question actually, which is that I feel like in your argument there is some conflation between section 3 subclause 4, which arguably I think requires you to establish or as a precursor to understanding whether you can cause AEC is actually substantial market power, which is quite different from saying that you are in a position of dominance required under section 4 where you can act independently of your competitors. That's in the explanation. So forget about the European Union, our own Competition Act talks about acting independently of your competitor under section 4. Correct?
Yes, sir.
So my question to you is, in the specific situation here, even if you are not able to, as your argument suggests, act independently of your competitor, and therefore you are not in a position of dominance, is there not a possibility that you are substantial, you have a position of substantial market power, in which case even if you do not return a finding under section 4, we may have under section 3 subclause 4?
Definitely, sir. And that brings me to my submission. We are contending that we do not even have enough market power to cause violation under section 3(4). Now, for market power, what is market power? It essentially means our ability to influence price in the market, the demand and supply in the market. In the present case, we have a strong competitor who is at the same footing, if not more, which means that we cannot independently influence the price. The moment we increase the price, the consumers will very well shift to an entity which is offering lesser price. Therefore, we cannot act independently.
Lesser price is a problem because you've got to kind of the revenue where you said you maintain price parity. You effectively tailored the market to ensure that nobody shifts.
So the price parity itself is a narrow price parity which has been accepted over jurisdiction. If you read the clause 5, it's
By itself, yes. But when taken in a combination of the other things, doesn't it then become a problem? In fact, all of these put together, in fact, require an investigation. Whereas it is only a price parity for happening.
additionally, sir, this is a completely voluntary MOU. And as in looking from the perspective of a
It's like saying Google, I don't need Google to do research.
So for multiplexes, I will give you an example and substantiate this one. From a multiplexes perspective, the MOU is required to be signed only if you need a zero interest loan or you want to be in the rating list. Now, MOU who already enjoys the goodwill of the people and have resources, which in general, the and multiplexes themselves have a goodwill. Why would they choose to restrict the visibility to an entity who has only 30 to 35% share? As a multiplex, I want as much as consumer possible to come to my platform and look into my portfolio, which means I would not choose to sign the MOU until and unless I am in a very dire need of either of the two things. And if you may say that any other entity might want to be in the rating list, for example, there is a ranking list of consortiums of NLU. However, NLUD chose to remain out of it. Still, there are goodwill of the people attached to it that they still prefer it over the ranking list that is released by the consortium. Which means that irrespective of the fact that whether you are on a ranking list or not, the goodwill remains with you.
How many instances of somebody who top last or was in the top say 10 in opted to LLB?
So the moment they do not get top three, they would prefer NLU Delhi.
The point, right? So then they're not comparable. If you don't get top 3, then LLB is really number 4.
So that is the fact, which means that even if the goodwill is, there are certain people who even if they get NLS, they choose NLUD. It depends upon the goodwill of the consumer and where it is attached. In case my goodwill is attached to INOX itself, irrespective of the
That logically, why should we have competition assessment at all? Because the consumer knows best. The consumer is always free to do what he or she wants.
Definitely.
They are going to their head.
Definitely, sir, but we have to look into the competition assessment because only consumers' benefit has to not be seen, also the competitors' benefits have to be seen. In the present case, since the as I was saying, the multiplexes, in until and unless they're in very dire need of resources, which again can be arranged, there are a lot of investors already available.
You get a 0% loan, and you get a 9% interest loan or 12% interest. What would you rather take?
So here comes the question of opportunity cost. Again, if I do not want an interest loan, then I would go for a zero interest loan. However, at what cost? Would I want to restrict my visibility only to 35% of the consumers and remain outside the visibility of 65% of the consumers? No. As an entity, as a multiplex who wants that more number of consumers come to them, they would rather go for a 12% loan wherein they can repay back the loan after the revenues they generate rather than restricting their visibility to nearly 35% of the consumer base. And therefore, we submit. Yes, sir.
So can you come to your prayer?
Definitely, sir.
What do you want?
So we want, may I recite the prayer or just simply state?
Like, prayer number 1, fixed there is not leverage. 2, fixed there is not denied market access. 3, fixed there is not entered into agreements in violation of 3. 4, fixed there is distribution of Mangaldas is not prohibited. The competition commission has closed the matter 60 at the time, which is stage, by noting other reasons that why can we reach this finding on leveraging? At the most, we can say that perhaps no interference is required. But now you want us to give a positive finding in the appeal, which in the first instance, CCF had not occasion to return those findings.
The fact that they have dismissed the allegation shows that they.
For business on what ground? That's an important one.
So the allegations that was put was regard to leveraging, tie-in, and denial of market access.
But at the end of the day, cannot go into the
Exactly, sir. Since CCF themselves dismissed the
so
allegation.
we can give these findings just by taking these
Sorry, sir.
this finding can be given, as you said, that we are not leveraged. It can be only given if we first return a finding that you have document. So are you inviting us to return a finding of document against you?
No, sir. We have.
Can we do that? Do we have the mandate to do that?
No, sir. You can at max direct the commission to reopen an investigation, which we do not. Which the applicant themselves have not prayed in the present case.
Doesn't matter. We've given us that omnibus form. We can do what we want.
Additionally, sir, the fact that we have already proved that we are not dominant is specifically that there is no prima facie case of dominance does not require an investigation to be opened. Thank you, sir. It was indeed an honor answering.
The council has 2 minutes for its rebuttal and will substantiate on certain points. Firstly, the council keeps claiming that Trickster competes with the box office sales and have relied upon the brief description of what Trickster does in this proposition of paragraph 8, completely ignoring legal precedences where they've observed that online intermediary platforms, when they deal with sellers, indeed, your lordship, but
But para 4.
Your lordship.
Look at legal precedent when the facts are important.
your lordship, when you look at
Are you
the,
disputing that fact?
your lordship, it's a brief description of what
Are you
Trickster does.
disputing what is set out there?
Your lordship, in paragraph 8, it can be observed that Trickster claims to compete with the sale of box offices. This cannot be held as a certain fact. Now, your lordship, secondly, it can be observed that the counsel for the commission and Trickster keeps claiming that there is no prima facie order. When there's they don't find a prima facie violation in this case. While in the case of Vijay Gopal versus Moot Show, there is similar agreements between theatres and multiplexes and online booking platforms, and they have found a prima facie contravention of the same. It is puzzling how the commission is able to find different prima facie violations in two different cases. Thirdly, your lordship, the council keeps claiming that the fixer still continues to provide cashback while it has actually mandated upon its consumers the use of rodeo. They also use the market report to claim that in-house brands have a ability to, brands do have an ability to create in-house products. What they have not provided that in that market report, it's not substantiated that they tie the in-house brand with the product. For example, Amazon does not tie its Amazon Pay with its product. They choose to do so if they find the convenience to be good. Additionally, your lordship, they keep claiming that consumer data sets cannot be shared or does not need to be shared. It's at the price that is reasonable. While in the case of KPN Telecom, it was observed that if a telecom, in that case it was the telecom industry, collected data, which is important for providing services, charge high rates for that consumer data, it can result in a denial of market access because it significantly raises the cost of its rivals. Your lordship, the time is over, but if I may address two more rebuttals, I should be obliged to do the same. They keep claiming that the present case, the price parity is a narrow price parity clause. A narrow price parity clause is a clause where the restriction is only on the seller, but it is clearly stipulated here that the seller cannot sell on any other online booking platform. This becomes a wide price parity clause, your lordship, and the same has been held to be in contravention of section 4, clause 2, subclause A is with section 4, clause 1. And finally, your lordship, they keep claiming that zero monetary loans are being provided and there is incentive, but they keep dismissing the fact that in the present case, for your clarification, market reports between India and foreign can be read as pari-materia. If we can look into market reports of the occupancy rate of theatres and multiplexes between 2020 and 2021, we can see a drastic decrease from 35% to 9% in the occupancy rate due to certain external conditions that we're all aware of. Providing zero interest monetary loans does in fact impinge upon them and tries to act as a loan shark upon these entities, and thus they're trying to get into agreements which can be in their favor. In conclusion, Your Lordship, we are contending that our argument still stands. It was a pleasure arguing before the council.
Last time it was an honor. Now it was a pleasure. Sure.
So coming to the first contention, that is, it competes with box office, the facts themselves clearly state and therefore it cannot be contended. Secondly, that there is prima facie.
Sorry, I think he was using a nuance. He said that it is your assertion that unclear statement of fact.
So for that, I would like you to refer to paragraph 8, that it does not say that it is an assumption. It is a paragraph that is introducing fixture, and therefore it's not an assertion. Further coming to their contention that the facts are similar to Book My Showcase. In that, however, we would like to point out that the market share of Book My Show was 78%. Here, the market share of Trickster is not even 30% in the market that we have determined, and therefore the contention that was raised in Book My Show cannot be applicable here. Additionally, talking about the cashback scheme, the fact that the Moot proposition and the clarifications when read together, it clearly shows that the consumers were benefiting out of the efficient services, the ease of access, and the cashback that we were giving. Therefore, the contention that the cashback is something that is causing consumer harm does not stand. Further, they are talking about data. At one go, they're saying that data privacy is a concern, and at the same time, they're asking us to share the data. How is it possible that both of those things go hand to hand? Either they can say that none of us should collect the data, or we should not share the data, or they could ask us to share the data. Now they're saying that since there is a data privacy, therefore you should share the data with us also so that we can use it in our services. This does not make sense in the present scenario. Further coming to the example that they gave that during 2020 and 2022, there was a decline in the multiplexes. This was an extraordinary situation of a pandemic. However, post-pandemic, we are seeing that people are being encouraged to go to the multiplexes. The Pathan screening was, the movies gained so much of revenue in the present case. The people are going to the multiplexes because they have been forced to stay inside their rooms for over 2 years. This means that definitely, sir. Thank you for the lead on the argument.
Your lordship, with people concerned, yesterday we were informed that lordship cannot enforce it. Also individually decide. So that's what we were informed, but